statements by other people. Because there are so many possible hearsay objections, it can be difficult to get statements by other people in as evidence without knowing which hearsay objection you can use. See the hearsay section in video 1 for more information. In general, if it is a statement from another person that you want to present as evidence to the court, it is best to ask that person to appear in court as a witness. If the person is not willing to appear in court, go to the court clerk's office to get a subpoena issued to that person to require them to appear in court. Another option is to ask the court for permission to have your witness appear via telephone. You will need to file a motion requesting this with the court that states why it is necessary and then provide a summary of the type of testimony they will provide prior to the court date. Lay witness. There are witnesses that are not testifying as experts, but who are providing their opinions. These witnesses can testify as long as their opinion is based on what they saw, heard, felt, or otherwise sensed. Their opinion is not based on scientific, technical, or other specialized knowledge. The requirements for testifying as a witness are: the witness must have personal knowledge of the matter, and the witness must give an oath to testify truthfully. Character evidence. In general, evidence of a person's character traits, or past behaviors is inadmissible. For example, if a person is known to be violent, mean, or that the person has a history of protection orders filed against them. There are certain exceptions to this general rule. For in-depth information, consult with an attorney. Some of the main exceptions that allow character evidence to be admissible are: in criminal domestic violence trials, Colorado has a special law that may allow evidence of past domestic violence. Evidence of other crimes, wrongs, or actions may also be admissible to show the following: intent, preparation, planning, scheme, opportunity, knowledge, identity, and absence of mistake. Reports by Child Family Investigators, CFI, and Parental Responsibility Evaluators, PREs. If a CFI or PRE provides you with a report, then by law, this report is admissible as evidence without any further steps to take on your part. Note about privileges. There are certain relationships where communication between you and that person are protected, including therapist-patient privilege in most cases, attorney-client privilege, spousal privilege, and clergy privilege for people seeking spiritual advising. Example: your therapist cannot be called into court to testify against you because of privilege. There are many complex rules on privileges. Please consult a lawyer for more information or with any questions. You can cancel or waive this privilege and allow the person, such as your therapist, to talk about the communication. Note: you and you alone cannot cancel or waive your child's privilege in court to allow the therapist to say things your child has said. Both parents must give this permission. Also, a letter or report from a therapist will not automatically be admissible in court because it is considered hearsay. See hearsay section in video 1. If you want the information in the therapist's letter or report to be presented to the court, you will need to call the therapist as a witness in court and have him or her testify about the report. Click on the links below to go to Video 1, What Evidence Is and How the Court Accepts It, and Video 2, Evidence in Family Law or Domestic Relations Cases. Also, click on the survey link below to provide feedback so we can improve on these videos. Thanks.